Good day everyone. In this video, we will be discussing the key concepts and topics that are covered on the most recent bar exam syllabus. Whether you are a law student preparing for the bar exam or just interested in understanding the legal framework that governs the political system in the Philippines, this video will provide an overview of the subject matter. We will be covering topics such as the Constitution, branches of the government, the electoral process, administrative law, and local government law. Our goal is to help you navigate through the complex principles of political law and provide you with a clear understanding of the materials covered on the bar exam. So sit back, relax, and let's begin our journey through the world of political law. Disclaimer: the video is not intended as legal advice. This video is produced for entertainment purposes only. Viewers should not rely upon the information presented as legal advice. Although the video is accurate to the best of our knowledge as of the date of its production, the law changes constantly and viewers should consult an attorney for specific legal advice. It is important to note that this video is not a substitute for actual bar exam review. While the video provides an overview of the topics covered in the bar exam, it cannot replace the comprehensive review and study that is required to succeed in the exam. This video should be used as a supplement to your preparation for the bar exam and not as a replacement for it. Let's begin. What are the parts of the Constitution? The Constitution of Liberty, the Constitution of Government, the Constitution of Sovereignty. What comprises the Constitution of Liberty? It is a series of prescriptions setting forth the fundamental civil and political rights of the citizens and imposing certain limitations on the power of the government as a means of securing the employment of these rights. An example is Article 3 of the Constitution. What comprises the Constitution of Government? It relates to a series of prescriptions outlining the framework or organization of the government, enumerating its powers, laying down certain rules relative to administration, and defining the electorate. For example, Articles 6, 7, 8, and 9 of the Constitution. What comprises the Constitution of Sovereignty? It consists of provisions pointing out the mode of procedure by which formal changes in the fundamental law may be brought about. Specifically, Article 17 of the Constitution. What are the manners of interpretations for constitutional provisions? Self-executing and non-self-executing character. What is the self-executing character of constitutional provisions? It is a provision which is complete in itself and becomes operative without the aid of supplementary or enabling legislation, or that which supplies a sufficient rule by means of which the right it grants may be enjoyed or protected. What is a non-self-executing character of the constitutional provisions? These are not judicially enforceable constitutional rights and can only provide guidelines for legislation. This provision merely lays down general principles. What are the elements of the state? People, territory, government, and capacity to enter into relations with other states. The general rule in interpreting the character of constitutional provisions is that all provisions of the Constitution are self-executing. What is the exception? Statements of general principles such as those in Article 2 are usually not self-executing. Other examples in jurisprudence include constitutional provisions on personal dignity, sanctity of family life, the vital role of the youth in nation building, value of education, social justice and human rights, promotion of general welfare, vital role of the youth in nation building, promotion of total human liberation and development are merely guidelines for legislations. All statements of general principles in Article 2 of the Constitution are usually not self-executing provisions. What is the exception? The right to a balanced and healthful ecology is self-executing, based on the case of Oposa versus Factoran. What is the principle of self-determination with regards to statehood? Self-determination is the right to independence for the people of non-self-governing territories and peoples subject to alien subjugation, domination, and exploitation. What are the types of self-determination? Internal self-determination and external self-determination. What is the principle of internal self-determination? A people's pursuit of its political, economic, social, and cultural development within the framework of an existing state. It pertains to autonomy. What is the principle of external self-determination? The establishment of a sovereign and independent state, the free association or integration with an independent state, or the emergence into any political status freely determined by a people constitute modes of implementing the right of self-determination by that people. It pertains to independence. What are the fundamental powers of the state? Police power, eminent domain, and taxation. What is police power? It is the power vested by the Constitution in the legislature to make, ordain, and establish all manner of wholesome and reasonable laws, statutes, and ordinances, either with penalties or without, not repugnant to the Constitution, as they shall judge to be for the good and welfare of the Commonwealth, and for the subject of the same. Where is police power lodged? The legislature. May police power be validly delegated by the legislature? Yes. May be validly delegated by the legislature to the president, administrative board, and lawmaking bodies on all municipal boards. Can you avail the remedy of mandamus to coerce the exercise of police power? No. What are the requisites of a valid exercise of police power? There should be a lawful subject and the lawful means or methods employed. What are the constitutional limitations against the exercise of police power? First, the Due Process Clause, and second, the Equal Protection Clause. What is the power of expropriation? It is also known as the power of eminent domain. It is the power of the state that enables it to forcibly acquire private lands intended for public use upon payment of just compensation to the owner. What are the requisites for a valid exercise of the power of expropriation? First, it should be for a public use or purpose. Second, payment of just compensation. Third, subject property must be private property. Fourth, valid taking of the subject property. And last, due process must be observed. Define public use. It is the general concept of meeting public need or public exigency. The term public use has now been held to be synonymous with public interest, public benefit, public welfare, and public convenience. What is the rationale of the doctrine of delegation of powers? Potestas delegare non potest delegare. What has been delegated cannot be further delegated. It is based on the ethical principle that delegated power constitutes not only a right but a duty to be performed by the delegate through the instrumentality of his own judgment and not through the intervening mind of another. What are the tests used for a valid delegation? The completeness test and sufficiency of standards test. Discuss the completeness test. The law must be complete in all its essential terms and conditions when it leaves the legislature, so that there will be nothing left for the delegate to do when it reaches him except to enforce it. Discuss the sufficiency of standard test. The sufficiency standard test means that the law lays down adequate guidelines or limitations to map out the boundaries of authority of the delegate and prevent the delegate from running riot. The standard must specify the limits of the authority of the delegate, announce the legislative policy, and identify the conditions under which it is to be implemented. What is the doctrine of royal prerogative of dishonesty? It is also known as the doctrine of state immunity. The state may not be sued without its consent. What is the basis of the doctrine of state immunity in international law? Immunity is enjoyed by other states consonant with the public international law principle of par in parem non habet imperium. An equal has no power over an equal. How do you test if the suit is against the state? See whether the enforcement of a decision rendered against a public officer or agency pleaded requires an affirmative act from the state, such as an appropriation of the needed amount to satisfy the judgment. What is the restrictive doctrine of state immunity from suit? Under the restrictive doctrine of state immunity extends only to acts jure imperi, sovereign and governmental acts, and not to acts jure gestonis, private, commercial, and proprietary acts. The restrictive application of state immunity is proper only when the proceeding arises out of commercial transactions of the foreign sovereign, its commercial activities, or economic affairs. Stated differently, a state may be said to have descended to the level of an individual and can thus be deemed to have tacitly given its consent to be sued only when it enters into business contracts. It does not apply to where the contracts relate to the exercise of its sovereign functions. What are the exceptions to the state's immunity from suit? Where there is consent, express or implied, a suit may be filed. When is there express consent from the state to be sued? There is express consent when there is a positive act from the legislature through the medium of a duly enacted statute, may be embodied either in a general law or a specific law. When is there implied consent from the state to be sued? When the state enters into a business contract or itself commences litigation. If the government files a complaint, defendant may file a counterclaim against it. When the state files a complaint, suability will result only when the government is claiming affirmative relief from the defendant, when it would be inequitable for the state to invoke its immunity. In instances when the state takes private property for public use or purpose. What is the rule when an incorporated government agency is sued? If the charter provides that the agency can sue and be sued, then the suit will prosper, including one for tort. The provision in the charter constitutes express consent on the part of the state to be sued. What is the rule when an unincorporated government agency is sued? First, inquire into the principal functions of the agency. If governmental in character, no suit without consent. If proprietary in character, the suit will prosper because when the state engages in principally proprietary functions, then it descends to the level of a private individual. If an LGU is sued, what is the rule? Every local government unit shall have the power to sue and be sued, based on the local government code. If public officers are sued, what is the rule? The doctrine of state immunity extends its protective mantle also to complaints filed against state officials for acts done in the discharge and performance of their duties. If a suit is filed against another sovereign state, what is the rule? Under the principle of sovereign equality of states, one cannot assert its jurisdiction over the other. Thus, a state cannot be sued in the courts of another state, as this would unduly vex the peace of nations. If a suit is filed against international agencies and their official, what is the rule? International agencies and their agents enjoy immunity from suit in the Philippines. What are acts juri imperi? Contracts entered into by the government in its sovereign capacity. What are acts juri gestonis? Contracts entered into by the government in its commercial and proprietary capacity. What is the archipelagic doctrine? The waters around, between, and connecting the islands of the archipelago, regardless of their breadth and dimension, form part of the internal waters of the Philippines.